So why do we have such a small number of public interest lawyers? Why is it that the majority of a graduating class from law school chooses to join corporate law firms rather than public interest organizations? Why is there a prevalent notion that you cannot have a successful legal career doing public interest law? I'll try and answer some of these questions using my own career and experiences. So when I was in law school, I was involved in a lot of social rights movements. And for me, it was a very natural progression to be wanting to do social justice work. So I finished my law degree. I did a master's in the UK and came back and joined one of the most well-known feminist human rights lawyers in the country. I had a short stint in the Supreme Court as a junior counsel, working on some of the most well-known public interest cases. These cases made the news and headlines all the time. I then came back to Bangalore and started my own practice with a litigation firm, but also doing pro bono work on the side. And one of my first cases was representing Mary. Mary and her child were thrown out of their home by their in-laws after her husband had died. This was my first trial court case. I had no trial court experience, having just come back from the Supreme Court. And I was up against a very, very senior lawyer who was representing Mary's in-laws. In India, at that time in 2000, we had no law which protected the rights of women to live in their matrimonial home. So I had to literally use every provision of the Civil Procedure Code to make sure that we could use it for her benefit. Finally, the very well-known lawyer representing her husband's family backed out of the case when we won a restraining order protecting Mary from dispossession from her matrimonial home. And ultimately, she won the case and also got a very good settlement, which helped her move on in life. Following my stint with the firm where I was working, I started my own practice and also started and co-founded the Center for Law and Policy Research in Bangalore, where we have a small but intense constitutional litigation unit working on public interest litigation all over the country. While I had a very positive experience working in the trial courts, working in the High Court and Supreme Court was different. I did a lot of disability rights work, gender, transgender rights work, and realized that judges in India, at least early on, were quite biased against many groups that I was representing. I did, for about 7 years, a lot of work representing blind and visually impaired persons for their rights in public employment. And once I had, we would challenge, for about 7 years, we challenged every government notification which excluded blind people from applying for government jobs, even though they had the qualifications. So I once had a judge in the High Court ask me, why are you always representing these people? Almost out of shock and anger. And so I asked him back, I said, how come you don't ask this question to lawyers who are always representing mining corporations, But I can say that after really 10 years of litigating for disability rights in the Karnataka High Court, we now have a court that champions disability rights in India. So that is really satisfying. So I come back to my first question. Can you have a successful legal career in public interest law? And I would say absolutely. How do you define what is a successful career for a litigator? And I would say there are mainly 4 elements that I would recognize. They are, first would be work that is meaningful, challenging work. Number 3 would be recognition in your profession. And lastly, money. So let's start with the first, meaningful work. I think contributing to social change, doing meaningful work gives you fulfillment and the satisfaction that you're doing something beyond just yourself. And doing public interest law work gives you the opportunity to bring about social change like no other field of law can. Last year at CLPR, we took up a case representing Akkai, who's a very well-known transgender rights activist in Karnataka, and a sexual minorities organization, Jiva, in challenging Section 36A of the Karnataka Police Act. Section 36A is a colonial provision which criminalizes transgender persons and allows the police to maintain a record of their whereabouts. There was a constitutional challenge to this provision, and after a huge public campaign against it, the government agreed to withdraw this provision. And the section was amended, and all references to eunuchs, or how transgender persons were referred to in the law, were removed. If I could. This is in the High Court just after the decision was passed, with Akai and Uma and other members of their group. This brought about social change on the ground. It led to police violence and police threats actually reducing. And this was a first anywhere in the country for the trans community. The second aspect, doing challenging work. Some of my most difficult and challenging cases have actually been doing public interest work. I got the opportunity to fight some of my biggest cases right from the trial court to the Supreme Court of India, only very early on in my career, only because of my public interest and pro bono work. These cases have put me up against the biggest and most well-known lawyers in the country. And that has been a very, very rewarding and challenging aspect of my career. In fact, one of my our latest wins have been a case where I argued in the Supreme Court on the issue of child marital rape. And on the 11th of October, like a thunderbolt, Evan, the Supreme Court gave a decision declaring that sexual intercourse within marriage with minor wives would be rape. This was a decision that just came out early this month. The third aspect, recognition and advancement in your career. Doing public interest law work, I found, gives you recognition and really can lead to an advancement in your career. And we have seen this, we've seen examples of this everywhere. We've had all over the world, we've seen how public interest lawyers are getting recognition for their work and contribution to the legal profession. We've had in the US Justice Thurgood Marshall, who started the NAACP. He was made a judge to the US Supreme Court. In Israel, Justice Daphne Barak Erez, who's a judge on the Israeli Supreme Court, was an academic working on gender, constitutional law, and human rights. In India, Indira Jaisingh, the founder of Lawyers Collective and one of our most prominent public interest lawyers, became the first woman additional Solicitor General. The Indian Supreme Court has now passed a judgment recognizing pro bono work as a criteria for designating lawyers as senior counsels, or the equivalent of Queen's counsels. And the government is now considering using pro bono work as a criteria for elevating lawyers to judgeship. This is happening really in the country now. And we can see that doing public interest work can actually advance your career. So, what has it meant for me personally? Personally, in my career, I've met some of the most amazing and inspiring people, all doing pro bono and public interest work. My first client, Mary, whom I represented in 2000, still meets me every Christmas with Christmas cake and gifts. My disability rights clients, who are all into government jobs now, help me with government documents and circulars and notifications for all my new disability rights cases. So it has been a really, really great ride. I think we have to build a culture of promoting public interest law in the legal profession. And at CLPR, that's what we're trying to do. We're trying to make public interest law as a meaningful and sustainable career option for lawyers. We are now introducing a justice fellowship program where we intend to recruit justice fellows from the best law schools in the country and expose them to 2 years of public interest law work. We're also trying to get donors within the country to support a cadre of public interest lawyers. And all of this is really with the hope that one day choosing public interest law would be, as a career option, would be the norm rather than the exception.